We are honored to have Justice Vineet Kothari, sir, who is a former acting Chief Justice of Gujarat High Court and currently practicing as an advocate at the Supreme Court of India. Sir will going to deliver the session on interpretation of statutes as part of 10 days online national capacity building program on legislative drafting, public policy making, and legislative analysis. So, welcome you, sir, in this program. And over to you, sir, now.
Thank you. Uh, Friends, this is a very important yet very general kind of topic for lawyers and judges because interpretation, as you know, of the statute, the golden rule also everybody knows is the plain language and plain meaning. So you have to attribute the meaning of the plain language in the statute. Now, sometimes what happens is that the controversies for interpretation arise mainly because the object which is sought to be achieved by that particular legislation is not absolutely possible or say absolutely 100% in accordance with the language of particular provisions. There may be some kind of inconsistencies and some kind of conflicts between the provisions here and the other chapter and etc. Therefore, these type of questions do arise in the process of justice dispensation many occasions. And that is why you will find a big commentary by G.P. Singh and all other authors on the interpretations itself. Now, there are several rules or I would say the points which should deserves to be taken into account by the lawyers as well as judges while dealing with the controversy in their head. We are not only concerned with the interpretation of the statute particular. Now, statutes, as you know, as far as our country is concerned, thousands and thousands of laws are there. So, and the areas of justice, you broadly take it, are civil, criminal, constitutional, jurisprudential. All these things have to be taken in a holistic manner so that the interpretation is such which would serve the purpose of that legislation which we are concerned with. For example, income tax cases, which I generally deal with, though it's a complex subject and perhaps too special or too technical a subject for a layman or a student kind of thing. But what I want to tell you really is the level of interpretation can go up to what level has to be understood. Now, firstly, the legislation itself, the draftsman skill is tested in legislating a particular enactment. Now, as you might have heard also, that Income Tax Act 1961 is now sought to be replaced by new enactment Income Tax Act 2025, which is in the bill form as of now. And it's with the special committee, and soon it is likely to become an act also. They have said that we have tried to simplify the law, we have reduced the provisions, number of provisions to half, and all proviso and expressions have gone. And one very interesting thing which they've done in Income Tax Act is that the non-obstante clause, for which the famous words and came up for interpretation on thousands of occasions, was notwithstanding anything contained contrary. That made the provision non-obstante clause. Now, non-obstante clause means what? Generally, to be understood by the students community and all of us in legal fraternity, is that non-obstante or notwithstanding would mean that notwithstanding any other thing said in that particular enactment. That means this provision which we are now saying will override and have the overriding effect over the other provisions. That is called non-obstante clause or notwithstanding clause. Now that generally, though I am not in a great in favor of these kind of provisions because they create more problems than solving the problems. But anyway, you will find these provisions in almost all the legislations. Now, in Income Tax New Act, they have substituted the word irrespective of. In place of notwithstanding, the legislation in its wisdom has thought it fit to substitute the word irrespective of. Now, the difference between the two, irrespective of and notwithstanding, is very fine. Notwithstanding means this provision which you are now telling you is going to override. Irrespective would mean Whatever has been said above, before or afterwards, has to be forgotten. And this provision alone will cover or govern this field for which we are talking about. Difference is not much. Ultimately, the intention of legislation in such provisions is to make that provision to have an overriding effect. Now, what happens when there are conflict in the overriding provisions or the general provisions which has governed the field for so many years? Suddenly you say that notwithstanding, or in income tax new law, you say irrespective of anything, this is the going to be provision. That creates kind of situations where a special class which is sought to be served by that provision comes in conflict with the general class, I would say. So then the thing is, now still the all the process of interpretation of statutes, the object is simple and one, that the object sought to be achieved by that legislation should be achieved. And for that, the interpretation process should be undertaken in such a manner that that object is not defeated. Therefore, the courts have sometimes said that interpretations which is absurd or irrational or which defeats the purpose of the legislation has to be avoided. So this is a step beyond the plain language, plain interpretation thing. When you interpret a particular provision, you must always keep in mind the object of that legislation. Like Income Tax Act is created to tax the income. Now, to tax the income, it has several aspects. You can tax the current income, cash income, accrued interest income, capital gains. All these things are in different chapters of the Income Tax Act. So, object is to tax that income. If you have heard something about international taxation, I am taking you for the text for just to explain you the extent of interpretation required in such complex tax laws also. International taxation is governed also inter alia besides the domestic tax legislation like Income Tax Act by the treaties between the two countries. If you have heard of double taxation avoidance agreements, they are treaties between the two sovereign countries, two or more. These are days of multilateral treaties, also MLIs. So those treaties, as per Section 92 of the Income Tax Act, has to have overriding effect. Now that treaty, if you know the legislative practice of that, is never like an act passed by the parliament. That is an executive to executive agreement between the two countries to avoid double taxation. There are several questions. Presently, I think constitutional courts, high courts and Supreme Court, if they are dealing with the tax issues, the main controversies before them is arising because of the interpretation of DTA versus supremacy of the domestic legislations. So interpretation is required not only in civil laws like property law, succession law, matrimonial laws, family laws, etc., but it's also required for the economic laws like Income Tax Act, like IBC, like Securitization Act, several acts. You know, economy works on a very complex set of laws. And if you are dealing with the banking laws also, if you have heard of them, if you are studying those laws also in your classes, then the special laws created one after the other. Like earlier, the bank used to file civil suits for recovery of their doubtful debts or the debts which are not being recovered in the routine course from the borrowers. They filed to civil suit. Civil suit started taking years and years. Even the decree was not granted. So they came out with this DRT Act, Debt Recovery of Debt Tribunals Act. That came in 2016 or so, or rather earlier, 2009 or so. I don't remember the year exactly. I'll give you. So that created an institution of the banks, of the recovery institutions, which the bank would go to the debt recovery tribunal like a civil suit, file their application. The borrower will be called upon to give its defense and all that, and then the decree would be passed if the debt is genuine and has not been paid with the interest in accordance with the contracts. So that tribunals also got overflooded with the suits. Then they came out with the concept of this IBC, Indian Banking Resolution of the Debts Code 2016. Yes, that's 2016. In that, the whole concept of recovery of decretal amount was substituted by two parts: resolution of the recovery is one part. Then the effort was made to keep the concern as a going concern, so that the assets of the company which is not paying the debts do not going into disuse or non-users. So the whole concept of keeping the company or the asset or the business going on versus recovery and liquidation if necessary was brought into this IBC. So law also evolves from time to time. The process of interpretation of the statutes is a continuous process with the courts, and the principles of interpretation are very many. Like I said, firstly, the golden rule, plain language, plain interpretation. Read the provisions as it is stated, the language as it is given. Now, there are sometimes conflicts arising between the Hindi version and English version of the laws also. There, the Constitution says that English version will prevail, 248. Therefore, you have to keep all these things in mind when you are concerned with the interpretation of the statute. Now, the second or other controversy which can arise is sometimes there are conflicts between the judgments. How to do it? Now, that is again a controversy or an area of interpretation where certain principles the students of law should know. Like in legislation, it is said that the latest legislation will prevail. Likewise, in judicial precedents, the latest judgment will prevail. In that also, there are certain catches. For example, the earlier judgment of the Supreme Court is by 2 judges bench. And the later judgment of the Supreme Court is 3 judges on the same point. Then obviously, 3 judges bench judgment will prevail. But what happens if the 2 judges bench, there are 2 judgments and both are having conflicting views? There again, the problem arises. And then the third bench dealing with that finds that there is difference of opinion. The matter is generally referred to the larger bench. And the larger bench is empowered to take a view of its own and overrule or affirm any particular judgment as it is argued and discussed before them. So these processes of interpretation of statutes is not limited that you are reading a particular statute and interpreting it. It has to be done in a very comprehensive and holistic manner. Okay. Now, why precedents are important? If you are aware of Article 141 of the Constitution of India, it says that the law declared by the Supreme Court is binding on all the lower high courts, tribunals, and authorities, all the 3. Now, there is again a question on that. Law declared means what? Besides Article 141, there is Article 142 also. Article 142, if you heard of recent Supreme Court judgments, is invoked as an inherent power to do complete justice. Only the Supreme Court in the Constitution has that power of using Article 142. High Court does not have it. High Court has power of 226 and 227 in the Constitution of India. 142 powers can be invoked only to do complete justice in a particular matter. They can go beyond the statute also and pass such orders which they think proper will do the complete justice. But 141 clearly says that law declared, within commas, law declared will be binding on all the lower courts and tribunals. Now, what is law declared? Law declared means the law as interpreted by the Supreme Court after a proper debate or discussion, and then with reasons what the interpretation is given by the Honorable Supreme Court is the law declared. There is a difference between obiter dicta and law declared. Obiter dicta means observation or passing remark or passing observation. You must keep as a student of law, because this can be even a question in your question paper. What is the difference between law declared and obiter dicta? Obiter dicta is a passing observation which is not binding because it is not law declared. It is not the law discussed and declared and laid down by the Supreme Court. But observation is, what is the reasoning or process of reasoning going on in the mind of the judges who are dealing with the controversy? Those observations are also recorded in the judgment. Now, sometimes it also question arises that what do you do if the observation of an apex court is which is helping or aiding the particular conclusion arrived at by the Supreme Court? Should it not be respected? Should it not be binding? Should it not be helpful in deciding the controversies which come before you later on? Now, some courts have said that even obiter dicta by Supreme Court is binding on High Court. But some courts at the same time also said that obiter dicta is obiter dicta. It is not 141 law declared, therefore not binding. So it all depends upon a very fine reasonings given by the courts. What is binding, what is not binding. The line between law declared and obiter dicta is also very thin. Therefore, any controversy which is dealt with by the courts, you have to go through the entire context in which the court is discussing or interpreting a particular provision or a particular controversy or a particular case. That is why we generally advise students that whenever you read a judgment, don't go only by the catch note and head notes. Something much more always lies in the body of the judgment than what is written on the top of it by the editors. Editing is a great skill. I have myself done it for 6 years. So unless you read the judgment fully, you are bound to miss certain points which the editor should have put on the top of the judgment, which we generally read. For the shortage of time, the lawyers would read with the head note and then go to the court and say, this is the authority on this point. That is not sufficient. Sometimes the opposite lawyer or the court, if they are more deeper into the things, they will point out, have you read para number 46 of this judgment? In the context of what you are saying, something different is there. Then your argument is immediately watered down. Therefore, the context of any particular ratio or law declared, ratio is another word for law declared. What is ratio decidendi? The conclusion arrived on the basis of a particular reasoning given by the court is ratio decidendi, as against the obiter dicta. So these are fine distinctions of interpretation which arise in the process of reasonings given by the courts while rendering the judgments. Now, this can happen right from the level of a civil judge down below in the district judiciary to the Supreme Court, all levels included. All have to interpret the law in the light of the facts which arise in a particular case which is on their board. This importance of interpretation, friends, Lord Denning once said, ironing out the creases. What he meant by this ironing out the creases in the interpretation is that if the object of the object of the legislation or provision is to be achieved, if there are some creases or some सिलवटे जिसको बोलते हैं ना कपड़े में सिलवटे, तो आयरन कैसे उसको सीधा सफेद साफ करती है, उसी तरह से उस प्रोसेस से आप इंटरप्रिटेशन को ऐसा प्रेस करिए, इंप्रेस करिए, क्लीन करिए कि आपका ऑब्जेक्ट उस लेजिस्लेशन का अचीव हो. दैट डज नॉट नेसेसरली मीन कि इनकम टैक्स एक्ट की जब आप बात करें इनकम टैक्स की प्रोविजंस की कि जरूरी है हर इनकम पे टैक्स लगाना ही लगाना. आपको उसका ऑब्जेक्ट है भी, अगर इनकम टैक्सेबल नेट में फॉल करती है तो उसको टैक्सेबिलिटी आप उसकी अपहोल्ड करिए. दैट इज द ऑब्जेक्ट. The other word which comes usually in the interpretation process is rational nexus. Rational nexus to the object sought to be achieved. If a provision or a particular rule, for example, is not in the conformity with the main provision, then object sought to be achieved by that particular provision is defeated. Procedural rules, for example. That is why another principle which comes in this debate is that rules cannot go beyond the main statute. Now, in all legislation, you will find there are executive authorities to implement that enactment, like Income Tax Department, GST Department, Customs Department, Police Department, for example, IPCC, RPCU are governed there. All these departments interpret and do their work on the basis of the rules framed under that particular enactment. Now, rules, if apparently their language is in conflict with the main provision, then what will prevail? Obviously, the act will prevail. So the object sought to be achieved by that act, if it is sought to be defeated by the particular rule, that rule has to go. But rule does not go like a wind. It has to be considered and struck down by the court, competent court, and only constitutional courts have that power to consider and strike down the law. You must have seen recently some debate in the parliament. How can 5 judges strike down what 343 to 2 or these 542 people decide in parliament? NJC Act, you must have heard. National Judicial Account, this commission which was sought to be created for appointment of judges, the Supreme Court struck it down. Why? On the basis of Article 50, independence of judiciary. Now, according to them, if the power to appoint judges was left with the executive or the government of the day, they will introduce people who will be biased in their favor. My chosen man, a blue-eyed boy, blue-eyed man or woman. To avoid that, they said independence of judiciary will be in danger if there is a active role of executive or the government in the process of appointment of judges. Now that debate is ongoing even after the 5 judges bench judgment of the Supreme Court. People are still thinking why NJC is not possible in some form or the other. You have the supremacy, you have the veto power, you have the majority judiciary, but then the role of the executive, which is even otherwise there, should not be denied altogether in the name of independence. Why do you believe or why do you say that the government cannot select good people, fair people, independent people? How do you presume that? So that debate apart, we are concerned as legal fraternity how all these controversies do arise and how the courts apply themselves to interpret those particular provisions in a particular manner. Now see this NJC example. For achieving the independence of judiciary, they struck down a whole law which was passed by absolute majority of the parliament, including opposition. And they said, no, we consider that this will go against the basic feature of the Constitution of India. So what is the object? What is the nexus? What is the rational nexus? What is the plain language? What are the distortions? What are the possible defects in the legislation which are required to be taken note when the courts are doing their job? Is the whole process of interpretation. Now, there are several maxims which you all should also go through. I will not narrate those maxims one by one because they are maxims, they are mostly Latin terms which help and assist, of course, in understanding the law, because in those earlier days, first legal enactments and all these things happened there. Therefore, the law evolved there, developed there. But India is not far behind. Our system of judicial dispensation, right from any law you see, any era you see, Treta Yug se bhi dekh lijiye, Dwapar Yug se bhi dekh lijiye, law kya hai? Rules governing the society. And rules governing the society always come up for interpretation when you undertake the decision-making process. Decision-making process आप जब भी करेंगे, आपको लॉ का प्रावधान का इंटरप्रिटेशन करना पड़ेगा, और उन प्रावधानों का इंटरप्रिटेशन आपको एक सेट ऑफ फैक्ट्स पे लगाना पड़ेगा. इंटरप्रिटेशन का प्रोसेस जरूरी क्यों है? इसीलिए जरूरी है that you can arrive at a just and fair conclusion of a particular case. Otherwise, this job could have been done in the present days by AI tools also. You know the provisions, which sections will apply to which kind of facts. You put them in a computer, it will give a decision that yes, guilty or not guilty, property to this man or that man. But it does not happen. Whatever kind of AI tools you may bring in the process of your working, human brain, human intelligence, human intervention will always have a primary goal. So for the students of this age, when you are presently likely to come up in the field of profession, where all these tools and technology is your day-to-day part of working. Chat GPT, you all are using. Sometimes we also use, but we do not give it primary role. We use it for assistance. That balance between the technology and human intelligence should always be maintained, because in judiciary or in justice dispensation, whatever little experience I have got for the last 40 years, the reasoning is the most crucial thing. In any judgment, in any order, in any process of justice, if reasons are sound, fair, balanced, that judgment or reason will always be upheld. To achieve that objective of justness and fairness, justice itself, this whole process is the line through which you go. So, with these few words, I would like to make it interactive, so that I feel that whatever I said has gone down, and perhaps if you are looking in a different perspective, let me have that perspective, and if I can further elaborate on that, I'll be happy to do that. And that is how we always should interact in a legal debate or conference. Yes, madam?
Yes, sir. Thank you very much, sir. Now, participant, you can raise your hand and please ask.
You can type it your control, the query, or you can ask, unmute yourself and ask also. There's no problem. There are teachers to help you.
Yes, sir. So, participant, you can ask a question one by one.
How many participants are there? There are many. I am on my screen.
Yes,
I'm seeing. How many?
yes, sir. There are 65 plus.
65, 66.
Plus.
Yes. So, friends, unless you speak out, I will never know what I've said is correct or not.
Good afternoon, sir.
Yes.
May I ask one question?
Yes. Vikramaditya Rathod Sahab, ILS
Yes, sir.
Pune.
Yes, sir. Yes, sir.
You seem to be a doctor, means teacher.
Yes, sir.
Most
Yes.
welcome. Yes, sir. Tell me.
Thank you, sir. Thank you, sir, for your enlightening session, sir. Sir, as you have pointed out about the obiter dicta, can you, in addition to that, you have said that there are many courts which are considering it as a binding law, or there is some courts which are not considering it as a binding law. So, sir, can you give us some idea or the illustration on that point, that at when point, which point of time the court considered it as a binding?
Yeah. This controversy generally arises for Supreme Court judgments, where as High Court judges and High Courts and even lower courts, we generally are concerned or come across these kind of things. Now, obiter dicta, Supreme Court does not start its para by saying it's my obiter dicta. In a flow of the reasoning, in a flow of a judgment, they say something. But if it does not become part of the final conclusion or reasons to arrive at a particular conclusion, that cannot be said to be ratio decidendi, in contradistinction with obiter dicta. Now, sometimes if you see, some cases are neither allowed nor dismissed. They are disposed of. So that is a kind of middle path in the judgments which you see. Likewise, a ratio decidendi and obiter dicta are a path. Now, there is no drawn line, लक्ष्मण रेखा नहीं है दोनों के बीच में, पर ऑबिटर डिक्टा से आपको ये पता लग जाता है पढ़ने से. अब एग्जांपल तो रेडीली मेरे कोई ध्यान में नहीं है, मैं पढ़ के कोई भी जजमेंट का आप एनालाइज कर सकते हैं. वी कैन डू दैट. Generally in 142 judgments, the reasons given are obiters, and even the decisions are not law declared, but like in income tax, Ashish Agrawal's judgment latest, if you heard of that, the Supreme Court itself said that we are using this 142 powers to uphold reassessment notices of 90,000 SSCs, so that 90,000 SSCs do not have to come to Supreme Court. And we are saying so for protecting the interest of the revenue, so that they can go ahead with the proceedings. We are not deciding each and every notice on its own merits whether it is valid or not valid. So saying so was obiter. Conclusion was that we are upholding the reassessment notice and you can go ahead with the proceedings. Not is not law declared. That is why in the second round litigation, again the people went to Supreme Court, sir, what you have said is not law declared. Now what do we do? whether the limitation will apply or not, whether the initiation has to afresh done, whether the reasons are given to be by the assessing authority or not. All these controversies again happened. Then again Supreme Court gave a second judgment, again of course in favor of revenue. So, but these things are very fine distinction. But obiter dicta for sure is not binding. The Supreme Court itself, if the matter again goes to them, cannot say this was our law declared. So a contextual reading for deciding whether it's an obiter dicta or a ratio decision has to be done.
Thank you, sir. Thank you very much.
Yes, please.
Yes, sir. Good evening.
Good evening, Ruby ji.
Good evening, Sirji. Good evening. Sirji, highly appreciable and commendable deliberations.
Thank you.
Sirji, I have a question. As you said, balance between AI and human intelligence. So how do we justify principles of natural justice here in these statutes?
Principles of natural justice in?
All these statutes, how we have...
Yes. It's a good question, I would say. Now,
Thank you,
natural justice is not only opportunity of hearing. If you have read some judgments of Supreme Court, the Supreme Court has said that natural justice does not only mean that you give a notice and hear a person before rendering any decision which is likely to be adverse to him, but it also includes that the authority concerned who decides that notice should give reasons and pass a speaking order. In the courts, we have dealt with several orders of administrative authorities where the orders were few lines only and said, I decide like this. We said, what is this? It does not meet the principles of natural justice in the sense that where is your application of mind? What is your reason to say that I do not agree or I agree? Both these sides you have to give reasons. That is also part of the principles of natural justice, or audi alteram partem as we say. And therefore, natural justice is necessary in all the statutes. Now, in some of the taxing statutes, which I have dealt with, the rules did not talk of giving of a notice before passing an orders which had an adverse financial impact on the assessee. The validity of those rules were challenged. They were struck down only on the ground that they did not have the principles of natural justice incorporated in those rules. For example, the case which I dealt with was GST. Before cancelling the registration of a registered dealer, if you do not give him a notice and just say, since you did not file the returns in time, your registration is cancelled, the person or the entity loses his character of registered dealer. Now, that is obviously an order against him. How will you not give an opportunity for him to defend? How will you not give an opportunity to say that I was justified in not filing my returns for these reasons? So, therefore, natural justice is a natural justice which has to be part of the statutes. And the Supreme Court in 1977 said that the unoccupied fields of the legislation, we will read the principles of natural justice in those areas. And all these contractual matters and these things which go, service matters also like yours, disciplinary action taken, adequate opportunity not given for inquiry officer to the delinquent official. He is not allowed to cross-examine the other witness. All these are breaches of principles of natural justice. Therefore, even if it is not part of the statute, the concerned rules, it has to be read into to meet the final ends of justice. That is how I feel and I see the principles of natural justice into all this. Yes, please. I hope my answer meets your doubt.
Okay. Any other question, participant? You can ask. There's a question. There's a chat box from
Yes.
Shivani.
You can read that, please. It's not in my screen presently, or I can have a look at
Question
that.
From Shivani. Good evening, sir. When there was a controversy about the supremacy between parliament and judiciary.
About the supremacy of parliament judiciary, I can read that. The same was settled by Honorable Supreme Court in Keshwanand Bharti, Principal Basic Structure, Power Judicial Review. Keshwanand Bharti is, of course, a landmark. Nobody can doubt that. But again, cropping up in the example of NJC was given, what would be the probable solution to it? solution NJC case has been decided. So NJC is not on the statute now and not in the in the form also. That debate is going on because, as you might have heard, unfortunate Delhi judge incident. Now people say, what kind of judges you are appointing? How can judges be corrupt? Now it's prejudging, like whether he's corrupt, not corrupt, good, bad, indifferent, whatever, will be decided by the inquiry. We are nobody to say today that the man should not have been appointed. But now the debate of NJC is again propped up to ensure that judges are appointed by a process in which the executive and judicial both have a equal say, or at least a say, major say maybe of judiciary, but the say of the government is also there, which as judges we know is also there otherwise also. You also people know, media tells you everything these days. So this debate, who is supreme, will also remain. Whether parliament is supreme or whether judiciary is supreme will always remain. But constitution as it exists today, the power of judicial review given to the constitutional court cannot be taken away, not only because of Keshwanand Bharati, but several other judgments. And that power will always remain, including striking down a law. And they have to give reasons. It's not that just I don't like this law, therefore I'm striking down. No. Long judgments, long reasons are required to be given for all this. So this debate will go on and should go on. That is what is called development of law, evolution of law.
So there is another question in the chat box that word notwithstanding, which is now substitute in the new income tax bill as irrespective, does not it dilute the essence of statute and oversimplify it?
No. There is no question of oversimplification or dilution at all. These are, in my understanding, this word irrespective of is no better than outstanding. But it shows, it's just a departure from the earlier language just to show that what we say in a particular part of the statute will have overriding effect, and please don't question it. Go ahead with the object of that provision. Notwithstanding, at several places created earlier long series of judgments when they said non-obstante versus non-obstante, what do we do? Then they said later law will prevail. So this to avoid controversy, now they have come out with a lesser number of provisions in the new Income Tax Act. They say we have reduced the words of the Income Tax Act to almost half, and provisions also from 800 and so, including schedules, has brought down to 395 or something like this. So it's not oversimplification, but the irrespective and notwithstanding, when the time comes, the court will interpret them also, irrespective also. In my humble opinion, they are almost the same. Yes.
Sir, may I ask one more question, if you permit, sir?
Yes. I think
Thank you,
5
sir.
minutes.
Sir, I have two questions. The first one is there any difference in approaches regarding interpretation of constitution on the one side and the statutes on the other side? And sir, my second question is, sir, can you just enlighten us on General Clause Act, in the importance of General Clause Act in interpretation?
Yes. Now, constitution and statutes operate obviously in different fields. Constitution is the mother of all the laws. Therefore, the constitutional parameters given in Part 3 of the Constitution, which are fundamental rights and even legal rights elsewhere like property law and all that, are the basic laws. The other statutes laws governing specific fields in the society, like property, family laws, tax laws, customs laws, etc., has to meet those parameters. And that is why Article 14 is the broadest principal fundamental right in which all laws are tested, not only against Article 19, 1 A, B, C, D, E, F, G, F gone now, but Article 14 says anything arbitrary is also unconstitutional. But these things, while you considering the interpretation of the Constitution, does not come. Constitution, when you interpret the Constitution, you have to go by the constitutional morals and constitutional objects of the that particular chapter. So, for example, these fundamental duties versus fundamental rights. Now, apparently, fundamental duties in Part 4A is not enforceable. But the courts, by their interpretative process, have read certain fundamental duties into Article 21 as right of life, including dignified life, right of health, etc., environment, all these. And through this process, I will call it a genuine, genius interpretation of the Honorable Supreme Court, where they've sought to enforce the fundamental duties also through executive by connecting them with Article 21 and Article 40. So this process of interpreting the constitutional provisions is entirely different ball game, entirely different field, I would say. This does not come in the interpretation of statutes when you plain language, plain, etc., iron out the creases, nexus sought to be, object sought to be achieved, etc., rational nexus, etc. These are the differences. General clauses, as you know, the very act says the terms which are not defined in the specific statutes are contained in General Clauses Act, and their interpretation is to assist the achievement of the same object which the particular enactment had. And therefore, General Clauses Act is generally read with some particular statute. It is not a standalone or a stand-out legislation which is required to be interpreted. It is again read with the particular statute, and then to give it a harmonious balance between the object and this action, they use General Clauses Act for the purpose of limitation and etc., certain definitions.
Thank you. Thank you very much, sir.
Next, Srinivas MP. You raised your hand. You can ask.
NCLT is given, somebody is writing. NCLT is given order saying prima facie evidence to take up case by registering ECIR by ED.
Yes, sir. That is my question, sir.
I'm reading that. ED officials
Yes,
say NCLT has no authority to pass such orders. How to proceed or break supremacy issues between law enforcing authority. Okay. So NCLT versus ED. So I
Yes,
think
sir. Yes, sir.
it should not be a matter of doubt, sir, that the NCLT will prevail. ED officials are only at best the prosecutors or the complainants before the NCLT. Ultimately, the tribunal like NCLT or the courts created by the particular enactment, their interpretation will have to prevail. So if they say ECIR is prima facie evidence and we proceed on that basis, they can proceed. ED cannot object to it. Yes.
Sir, we
Yes.
have referred several times, sir, but they are not taking cognizance of this order, sir.
Who?
ED officials.
They say what?
Can we go for contempt?
No, you can. You
contempt of
should
court
go
of-
to the. You should go to the High Court to seek mandamus directions.
Okay, sir.
That is a better remedy. No contempt is made of.
Okay, sir.
Tribunals by themselves do not have any power of contempt, sir. Only constitutional
Okay,
courts.
sir.
That's why they are called court of record. The basic
Okay,
difference
sir.
between tribunal and court of record is court of record has the power to punish for contempt. Tribunals do not have any such power. They can only make report and send it to the constitutional court for proceeding further.
Writ of mandamus is the only.
Yes, you can ask the court
only remedy available.
to direct the ED and NCL to entertain or not to entertain, depending on the facts. Yes.
Oh, okay. Deeply obliged, Your Honor.
Thank you.
Now I would like to invite Dr. Kalpesh Gupta to give vote of thanks.
So before I give vote of thanks because as a teacher, so as a teacher, sir, how we should teach this subject in our law school? Because I have seen we are not effectively teaching this subject, and then what level this subject should come? Because I feel this subject should be maybe first, second year. It comes in between. Because how to read a particular law should come earlier part of our law school. So any
Yes, I
thought
think
on that?
is a good suggestion and question both, sir. I would not say question, but if you want my tip also, because I have also been a faculty member in law faculty here for a number of years, I think the best thing is to take book of interpretation of statutes. The basic principles are there, chapters are there. Teach them, tell them the principles. But if you give some examples of case laws on certain issues, particularly current issues, or some say 10, 20 years ago also some judgments have happened, in which depending on the statute concerned, some interpretative tools have been used or principles of interpretation have been used. I think if you take up the case studies with the simple theory, that can make your classroom more lively and engaging, and perhaps will put the things in the mind of the students for a longer period. So case study with book I think is a good way of taking the students along with the course. For that, you will have to have some judgments on your desk always.
Thank you very much, sir, for this
Thank
very
you.
valuable time and
Mr.
insight.
Ramakant, also I see in the screen. Any suggestion or comment from you, sir? You are also a teacher?
Yes, Mr. Ramakant.
Yes, Mr. Ramakant.
Yes, sir.
At least
I'm not.
you do not look like a student. So being a teacher, any comment or?
No, sir. I'm not teacher.
Acha. You are advocate?
Yes, sir.
Okay. Any comment or any suggestion from your side, sir?
No, sir. Already questions asked by the many persons, so I
Okay.
got the answer.
Thank you. Okay. So yes,
Thank you very much,
formal
sir,
thanks,
for
though I don't need it, but it's still way of
No,
life.
sir. Thank you very much, sir. You are sparing valuable time and insight and practical knowledge with us. And we have some student also, student, faculty members, and professionals who are attend this particular program. So I hope participants have been benefited out of the sir's insight on this interpretation of statutes. Very I would say crucial while reading a particular law and interpret particular law rule regulation at particular program. So thank you very much,
I
sir.
think next time onwards we'll take up some particular case laws or particular subject
Sure.
and then discuss some Supreme Court, High Court judgments. That I think, as I said, case study wise, it's always better. And we also rather give some particular tips on the case law so that the students who are going to become lawyers will know which field or which area of subject or which cases are more interesting, like leading Supreme Court judgments. Arbitration, a subject like ADR, there are binders of arbitration cases from Supreme Court recently. So number of judgments on arbitration law itself has come. So any topic which you select, I'm happy that this student committee, which is now in touch with me, Jayant and Hiranshi Shah and all these persons, young people, very bright people. So we should engage more in, and I'm always available for students. I will never say no. Days a little bit here or there. So subject to that, I think we can interact on particular case laws, particular subjects, controversies. That can be, I think, little more useful for them. Thank you. Anyways.
Sorry to interrupt, sir. I just want to know one thing, as you have mentioned about the ADR, from where we can start like to know more about the ADR. Can you just refer us some good books?
Why not, sir? ADR, there's so many books, sir. Arbitration Conciliation Act itself, you pick up commentary. Any one commentary of 200 pages plus, latest edition, of course. Then you'll read 2-3 Supreme Court judgments latest in the order. Now you click a button, you get Supreme Court judgment. So read few judgments, you will have an idea and insight into the importance of ADR as a subject, plus how much the Supreme Court is vigorously trying to lead all of us into ADR system. I am a very strong supporter of ADR system, and I am myself a trained mediator. I did training as a 40 years training as a sitting judge of Madras High Court, along with my 26 colleagues. And all were very happy to become students for 48 hours in the classrooms. So if you have an interest in the subject and a learning desire to learn always, you can always learn. And ADR is, in times to come, mediation and arbitration will be an equally important professional line for you young professionals also. There are now firms and firms doing only ADR practice. So it's going to be an order of the day, because courts people are now almost tired of this system and procedures and length of litigation and all that. So ADR, you must not only learn, you should practice. I would recommend that.
Yes. Thank you, sir. Thank you very much.
Thank you so much, sir, for your wonderful presentation.
Thank you.
Thank
Always
you very much, sir.
Anytime you can call upon me.
Yes, sir. Yes.
Thank you. Thank you, Jen.
Thank you
Thank
very
you.
much, sir. Jai.